Hello. Today we're going to talk about Article 5. Now, of all the articles in the Florida Constitution, Article 5 is the one that is greatest significance to lawyers on a day-to-day basis. Here's where you're going to find out how the courts are organized, how judges are selected, how judges are disciplined where that's necessary, how judges are replaced, and you're going to find out how the jurisdiction of the courts works. This is lawyerly exercise. These are things you simply have to know in order to be a competent lawyer, no matter what field of law you're engaged in. So let's go to our objectives. We hope, again, that you'll learn about the way the whole judicial system is organized in Florida. It's different from the federal system. We hope that you'll learn how people become judges and how they may be removed or disciplined for misconduct. You need to understand the court's rulemaking power. In any area of practice in which you engage, you're going to find that you're dealing not only with the rules that you've been studying in law school, the rules of civil procedure, but also very important specialty rules, especially rules relating to probate or criminal law or other subjects. And these rules are under constant revision. And so some understanding of how the rulemaking power works is essential for you as a lawyer. And then most important, you'll have to learn something about the jurisdiction of courts. When does a court have power? And over what subject matter does the court have power? Well, we begin with the way most of these early articles in the Constitution begin, and that is by defining what the judiciary is. The judiciary is that branch of government that has the power of the courts. The judicial power we'll see defined through a series of cases, but now that authority rests with this branch. Now, remember, back in Article 2, we dealt with the subject of separation of powers, and we're still dealing with that subject. And here we have the Constitution telling us that the judicial power shall rest with these courts. And notice, and we'll touch on this in a moment, notice that the types of courts that are state courts, or state constitutional courts, are identified, and no other courts may be established by the state. This is a provision that came in 1972, and you recall from your history of the Florida Constitution that that was extremely important because the trial court system in Florida had been very much fragmented with multiple types of trial courts prior to 1972. The legislature may divide the state into districts for appellate districts and to judicial circuits, but they must respect county lines. We have a number of commissions, and we'll have to look to our case law to show us where the lines are drawn about what administrative bodies can do and what they cannot do. So what we'll find when we look to the case law, we'll find that any sentence of imprisonment or jail will have to go through a court. It really cannot do that through an administrative proceeding. Fines may be levied by administrative bodies, but the way the judicial power is defined, only courts can do certain things, including deprive you of your freedom. Article 5, Section 2, this is, as I've said earlier, an extremely important provision of the Florida Constitution. I want you to look at it really very carefully. The Supreme Court shall adopt rules for the practice of procedure in all courts. Now, back in Article 3, we talked about the legislative power being with the Florida legislature. But do notice that some of the state's legislative power, that is the power over practice and procedure, is now lodged with the Florida Supreme Court. So the Florida Supreme Court adopts rules in the area of practice and procedure. That's within their jurisdiction. Original adoption of rules of practice and procedure are not within the jurisdiction of the legislature. They fall here. Now, that leaves us with a terrible dilemma, which we'll have to examine further as we examine the case law. What is practice and procedure? Well, what things may the legislature not involve itself in? And we're going to see several examples when we look through the case law. Now, continuing with Article 5, Section 2A, we now see a role for the legislature, and that role is not for the original adoption of rules, but for the repeal of rules. So, if the court adopts a rule of practice and procedure, that rule stands unless the legislature acts to repeal it, and that repeal must be done by 2/3 vote of the membership of each house of the legislature. So an extraordinary vote of each house of the legislature to repeal rules. Note that legislature still does not have the authority to adopt rules. So they may repeal an existing rule, but may not adopt a new rule in that rule's place. Now, as we look at the case law, we're going to find that the court has a very simple way to try to deal with this issue and try to prevent too much conflict with the legislative branch, and that is giving a great deal of respect to legislative enactments and the use by the court of its rulemaking power to adopt rules that are consistent with the objectives of the legislature. And this is done time after time. Virtually after every legislative session, you'll find new rules being adopted or rule proceedings initiated to address the subject that's been dealt with by the legislature, although the legislature did not have jurisdiction to deal in that area. It's a fascinating activity to follow because the court originally takes action following legislative enactments, and we do not have a contested proceeding. They just announced that rules have been adopted that fall into the court's jurisdiction for practice and procedure, and then proceed to adopt rules that further the legislative objectives. The Constitution calls for a Chief Justice to be chosen by a majority of the members of the court, and this looks like a throwaway line, but a very important line. Remember the kind of confusion we had in the court system prior to the 1972 revision of Article 5. Now we have a clear line of authority. We've seen rulemaking back earlier in Article 5, Section 2A. Now in Section 2B, we see that the Chief Justice now is the Chief Administrative Officer. So he's the person, or she's the person, and often in recent years it has been she. She's the person who actually gives directions to the rest of the court system. These directions are done in accordance with the will of the entire Supreme Court, which is consulted by the Chief Justice. Provisions in the Constitution for a Chief Judge in each District Court of Appeal and a Chief Judge in each circuit. Note now that this is continuing with the idea of having a clearly understood line of authority, starting with the Supreme Court and starting with the Chief Justice and now with the Chief Judge of each District Court of Appeal and a chief judge in each circuit. And the chief judge in the circuit is the person who's in charge of both circuit courts and county courts within that circuit. The Supreme Court, 7 justices. Over our history, remember, we've had periods of time in which we've had 3 justices or 5 justices or 6 justices, but we now have constitutional provision which requires us to have 7 justices. 5 will be a quorum, and the Constitution provides for the temporary assignment of justices where necessary. Now, Article 5, Section 3B. Pay very close attention to the words in Article 5, Section 3B. You now are going to find out how you get to the Supreme Court, and I want you to pay particular attention to the words shall and may. And so let's start off. It shall hear appeals from final judgments imposing the death penalty. Capital cases go from the circuit court, which has jurisdiction over capital cases, and at the end of that trial court decision or judgment, the appeal lies not with the District Court of Appeal, but with the Supreme Court. Direct appeal in capital cases from the circuit court to the Florida Supreme Court. And if you look at the docket of the Florida Supreme Court, you'll find that a great deal of the activity at the Supreme Court consists of handling appeals from the capital cases, and also handling post-conviction proceedings relating to capital cases. And so virtually all capital cases come through the Florida Supreme Court at least twice. And since the records in those cases are frequently quite extensive and the questions presented are numerous, you'll find that a lot of the activity of the Florida Supreme Court deals with the jurisdiction they get under Article 5, Section 3B, subsection 1. Now, we go to a different idea. When provided by general law, shall. So again, this is not the shall that is the constitutional shall. This is now a authority given to the legislature to adopt by general law provisions governing the jurisdiction of the Florida Supreme Court, and the authority given is authority to validate bonds and to review the action of statewide agencies that are involved in the setting of rates and utility services. We're talking about the Public Service Commission. So bond validation and Public Service Commission decisions go directly to the Florida Supreme Court. Again, continuing, we now find a may. It may review any decision of a District Court of Appeal that expressly declares valid a state statute, or that expressly construes a provision of the state or federal constitution, or that expressly affects a class of constitutional or state officers, or that expressly and directly conflicts with a decision of another District Court of Appeal or the Supreme Court on the same question of law. Now, I've tried to emphasize the word expressly, and that is because this word is critical. One of the areas where you see a large number of controversies relating to court jurisdiction is over conflict. Is a decision rendered by, say, a District Court of Appeal in conflict with a decision by another district court or a decision of the Florida Supreme Court. Well, that it has to be a conflict. It's not just in dicta, but a conflict that's actually on a point of law and that is expressed in the opinion. So in this subsection 3 of Section 3B, you have these multiple ways of getting to the Florida Supreme Court, but they all are preceded with the word may. So the Supreme Court has discretion about whether it will take jurisdiction. And now subsection 4. Again, notice that this starts off with the word may. So the court has discretion. And that is a little bit counterintuitive. So let's think this through. What it may do is it may take jurisdiction of a case that's certified to be of great public importance, or that is certified to be in direct conflict with a decision of another district court of appeal. So an appeal starts through the trial, after the trial level, it goes to the district court of appeal. District court of appeal now decides the case, or doesn't decide the case, but certifies to the Florida Supreme Court that this is a matter of great public importance, or certifies that it's a matter in direct conflict with another district court of appeal after the district court issues an opinion. So we now have an appellate court saying that a case is of great public importance, or an appellate court saying, after announcing an opinion, saying that its decision, its opinion, it conflicts with an opinion of another district court of appeal. So despite that certification, the Florida Supreme Court still has jurisdiction. It may or may not take jurisdiction of a case that's been certified under this subsection 4. So look at this carefully. Don't use your intuition. You have to use the wording of the Constitution. Again, subsection 5, may, excuse me, I'm sorry, Bud. We have to start again.
Okay, that's fine.
But was that the same?
Did you skip a slide? Or...
Okay, yeah, I'm sorry. I'll have to start this one again.
Okay, that's
May
fine.
I do that?
That's fine.
Okay, let's move to subsection 5. Subsection 5 again has the word may. So the Supreme Court has jurisdiction to review a judgment of a trial court. Now, a judgment of a trial court that's been certified by the District Court of Appeal to be a matter of great public importance. We dealt with that general subject earlier. But now the certification is to be, this matter is of great public importance and is has an impact on the administration of justice throughout the state, and it requires immediate resolution by the Supreme Court. I've had one case in my career that had such a certification, and that case related to whether or not a women's health care clinic, which is subject to a lot of fairly radical forces picketing and closing down access to the health care clinic, whether an injunction could stand. And after the trial court entered the injunction, the case was taken to the District Court of Appeal, and the District Court of Appeal then certified that case as a case of public importance and of statewide importance, and certified that it required immediate resolution by the Supreme Court. So we never argued the case in the District Court of Appeal. The District Court of Appeal passed it through. The whole idea of pass-through jurisdiction comes out of this section of the Constitution. And you need to understand that this is a tool in the hands of lawyers, particularly lawyers litigating extremely important questions of public law. Now we have another form of certification. Note again the word may. So it may review a question of law that is certified by the Supreme Court of the United States or United States Court of Appeals. So not a federal district court, but a federal appellate court or the U.S. Supreme Court may certify a question that the federal court decides there is no controlling precedent from Florida, and this now is a very important provision to protect federalism. It allows the state courts to decide state law even in a federal court proceeding. So you'll find a number of interesting state constitutional questions actually arise originally in the federal court, and the federal court then certifies that to the Florida Supreme Court for resolution. The federal appellate court certifies that to the Florida Supreme Court for resolution. But note that the word may appears here as well. I cannot think of an instance where the Florida Supreme Court has refused to address a question which has been certified by the federal appellate court or the United States Supreme Court, but they still do have that discretion, and you have to address that as you handle any appeal in which you've got a certification to the Florida Supreme Court. Now, an area which I like very much, because most lawyers don't fool with extraordinary writs, but in the area of constitutional litigation, you're going to find that we deal very frequently with extraordinary writs, and we need to make sure we understand what the writs do and what courts have extraordinary writ jurisdiction. Here, Section 7 and 8 give authority to the Florida Supreme Court to issue writs of prohibition and all writs necessary to the complete exercise of its jurisdiction. Now, the Florida Supreme Court case law says that this all writs language does not give a separate basis for jurisdiction. It relates to a matter which arises after the court has already taken jurisdiction in a case and a subsidiary question arises, and when the case is sent back, for instance, to a district court of appeal or frequently a trial court, and that case can then come back up to the Florida Supreme Court under its all writs jurisdiction. A good example is in capital cases. You get a Supreme Court deciding a capital appeal, deciding hypothetically that the trial court got it wrong, goes back for a new trial, and in the new trial, some subsidiary issue arises, typically something like whether attorney's fees can be assessed, and the trial court makes a decision on that subject, and then that subject now can come up for review the Florida Supreme Court under the all writs jurisdiction. So writs of prohibition now ask a body to whom the writ is directed, why should we not prohibit you from continuing in this matter? A writ of prohibition, again, would be used, for example, in cases where an administrative agency attempts to take on an issue such as the determination of the constitutionality of an act. Well, that rests with the judiciary, not with an administrative agency. And so you find the writ of prohibition will lie to allow the court to which that administrative agency would be reviewed to issue a writ of prohibition, and you see it occasionally. So writ of prohibition, and then subsection 8 writs of mandamus and quo warranto. These mandamus and quo warranto are issued to state officers or state agencies. So note that these now, writ of mandamus is an order. Prohibition says you may not do something. Mandamus says you must do something. And quo warranto says, ask the question, by what warrant, by what authority are you conducting proceedings? So quo warranto is used to challenge the jurisdiction of state officers or state agencies. And we're going to see in our development of the case law throughout all the articles of the Constitution the frequent use of these extraordinary writs, prohibition, mandamus, quo warranto. Writs of habeas corpus. Remember the issuance of a writ of habeas corpus now rests under the Constitution as one of these guarantees. Indeed, recall that in Article 1, we learned that you file a writ of habeas corpus. You do not pay a filing fee for a habeas corpus writ. And habeas may be issued by a justice, and the justice may make it returnable to the Supreme Court, to a district court of appeal or any circuit court. So may issue a habeas but have it considered in another court. And then a reference to provisions of Section 10 of Article 4, which we've looked at before, which is the authority to issue an advisory opinion to the Attorney General relating to the sufficiency of a petition being circulated as an initiative petition for amendment of the Florida Constitution. There's provision for a clerk and marshal who serve at the pleasure of the court. They're subject to the direction of the court. Now, Section 4, District Courts of Appeal. Shall have at least 3 judges, and 3 judges shall consider each case. Occasionally, the District Courts of Appeal will handle cases en banc, but there must be at least 3 judges for the initial decision. Again, look at the jurisdiction. They have jurisdiction to hear appeals from the final orders of trial courts. And so, whether it's a county court or a trial court, where that jurisdiction is provided by the legislature, and we'll see how that breaks down when we get to sections 5 and 6 of Article 5. We now have a case that gets to the District Court of Appeal. Note that it's the cases that are in the trial courts, including cases entered on review of administrative orders, but cases that are not directly reviewable by the Florida Supreme Court. So what are those cases which are directly reviewable by the Florida Supreme Court? Well, capital cases, we know. If the legislature passes, as indeed it has passed, a general law providing for bond validation and for review of Public Service Commission cases, those cases are directly reviewable by the Florida Supreme Court, and so those cases do not go to the District Court of Appeal. Interlocutory cases may be reviewed in accordance with the rules adopted by the Florida Supreme Court. Continuing with the jurisdiction of the District Court of Appeal, a direct review of administrative action as prescribed by general law. So statutory law will describe what administrative action by state agencies or local government agencies are reviewable by the district courts of appeal. And again, a listing of the jurisdiction of the court in terms of extraordinary writs. I want you to look over this list of extraordinary writs and note what is here in Article 5, Section 4 that is not present in Article 5, Section 3. Do you see the word certiorari? You didn't see certiorari back in Article 5, Section 3, but here it is. And so a district court of appeal has authority to do cert review, that is discretionary review of cases that come before administrative agencies or courts to which the District Court of Appeal provides appellate jurisdiction. So if it has appellate jurisdiction, it also has cert jurisdiction over those courts and agencies. The trial courts are going to get to be very, very easy. Their jurisdiction, circuit court gets everything that relates to trials that is not given to the county courts. So it's a matter of exclusion. Everything else, the Court of General Jurisdiction in Florida is a circuit court, and county courts have jurisdiction that's spelled out by general law, and we'll come to that when we go to Section 6 upcoming. So there's a circuit court for each judicial circuit. There are 20 judicial circuits in Florida, and the Constitution now sets out that the circuit court shall have the power of review of administrative agencies, which is prescribed by general law. Section 6, county courts. There'll be one or more judges, and for each county court is prescribed by general law. So in Dade County, how many county judges do you have to have constitutionally? One. You could structure a court system that has a single county judge in a county and have all the other trial judges be circuit judges. We have not done it that way in terms of legislative action, but constitutionally, you could have what really approximates a single-tier trial court in large counties. And the jurisdiction of the county courts, jurisdiction is what the legislature says it is. So, but it has to be uniform throughout the state. So all county courts have to have the same jurisdiction. Specialized divisions. At one time, the Florida Supreme Court met in specialized divisions. That's no longer permitted constitutionally. And the specialized divisions of trial courts, or for that matter, the appellate courts, can be established by general law. Eligibility. A person has to be a person of experience and may not serve as a justice or judge after 70 years of age. So the judges refer to this provision as a provision which brings about constitutional senility. After 70 years, they're constitutionally no longer allowed to serve as active judges. They can take what amounts to senior status, can retire, and can when assigned can sit on cases, but may not be in active service. The cutoff at 70 years is, in my judgment, ridiculously low. I think young people should be allowed to stay on the court. Eligibility, Supreme Court Justice and District Court Appeal, 10 years, members of the bar, circuit judges 5, county judges 5, and unless general law allows otherwise. And look at this provision. Unless otherwise provided by general law, a person shall be eligible for election or appointment to office of a county court judge in a county having a population of 40,000 or less if the person is a member of good standing of the bar in Florida. So now as we read that, what happens in a county of 40,000 or less? Is it possible for a person who's a non-lawyer to be a judge? And to determine that, we have to look to the statutes. Article 5, Section 9 is an interesting provision, somewhat disappointing in its application. I want you to think back now historically. Think that under Article 5, before the amendment in 1972, we had a provision that had automatic creation of circuit judges. Do you remember that provision that was reviewed in Gray versus Bryant? And it's the provision that says that where the census finds that a circuit has increased by 50,000 population, you add a circuit judge. So automatic addition of the numbers of judges. Well, with the elimination of that provision, when Article 5 was amended in 1972, we now have to have some method to determine how many judges are necessary. Well, this mechanism was developed as unique to the Florida Constitution. I don't think any other constitution has a similar provision, and it would be a wonderful provision if it actually worked. But it will work only if there's cooperation between the courts and the legislature. And sadly, that has been missing. So the mechanism for certification by the Supreme Court for the addition, or for that matter, reduction of judicial manpower has now been frustrated because of conflicts between the legislature and the courts, and the legislature has not been respectful of the court certifications in most recent cases. So Article 5, Section 9 was a good idea. It just simply hasn't worked under the present culture of legislative action. Again, the legislature has total discretion after the certification by the court, and of course that discretion has been exercised to essentially deny or ignore the recommendation of the court. Retention. This is a really important provision because it now provides for merit retention, and this provides the terms of the ballot language. Shall Judge A be retained in office? And that's the election. No longer contested partisan elections with the appellate courts. With circuit courts and county courts, you now, today, in 2014, you do not have any circuits or any counties where you have merit retention in place. It would be possible to have that through local option, and I hope that your generation of lawyers will pay attention to this. If you can find me a single lawyer in Dade County who can name all members of the circuit court and county court, then I'll retract what I'm about to say. But if you fail to find a single person, I'm going to ask you to think for a moment about whether we have any business electing trial judges when we have no idea who they are or what they stand for or what they're doing. There's just simply ignorance, even among most trial lawyers, about who these judges are. They may know a handful of the judges. If they're a criminal defense lawyer or a state attorney, they certainly know most of the judges who are in the criminal division, but they may very well never have heard of or met somebody who's in the civil division or over in probate or juvenile court. It's just incredible that we continue with election of judges. It's a system that really needs to be reformed, and here's the mechanism for reformation, one that your generation of lawyers can use as a really important tool of further reform. Same thing with county courts. Again, you have a possibility of a local option, and that again would make sense to me as you think about the agenda of what you're going to do when you're a practicing lawyer. These provisions now just continue with the procedure for a local option for circuit courts and county courts. Vacancies, the governor shall fill vacancies for judicial office, and she'll consider the recommendations of the judicial nominating commissions. And so the judicial nominating commissions are required to submit names of people who are qualified, and it has to be, they have to submit at least 3 names and may not submit more than 6 names to the governor, and the governor is required to pick from that list of names. Section 11B requires that the governor shall fill vacancies, and it requires that that these be filled on a basis that does not extend on to leave a gap in the judiciary. So what if a governor does not make a timely appointment? Well, here's a possibility. You go to the Florida Supreme Court and file a writ of mandamus and ask that the court compel the appointment from the list submitted. And in this case, Governor Christ had received a list of 6 names, but looking over the list found that it did not have sufficient diversity, although it did have women on the list. He then simply did not make an appointment, and the person who was vacating the position, Bob Ployce, who was on the 5th District Court of Appeal and whose father had been one of the original members of the 2nd District Court of Appeal, Bob Ployce brought an action, and this is a brief excerpt from the oral argument in that case.
But, Your Honor, if he has that evidence, if there's any suggestion of impropriety on the part of the JMC, then the governor can simply raise that. This court would never issue a mandamus against the governor who said, I'm not going to appoint where I know there's been some corruption. But let's make it clear on this record there is no such suggestion here.
But where is that in other words, where is that in the Constitution? I thought the way that this was being argued is that once those 6 names go up, that the governor has no authority other than to appoint from the list of 6
Your Honor,
names.
I think that's right. The Constitution says the governor shall appoint from that list. If you now do not enforce that shall, look where that takes us.
But that's what I'm asking you. But I'm asking but you would be saying, as long as there is no evidence of impropriety, corruption. But where are you getting that read into what otherwise sounds like a unbending, clear mandate that says shall appoint from that list.
Your Honor, from the court law, from the case law of this court, which says that you have discretion about whether to issue mandamus or not. And if you had instances of corruption in front of you, you have the discretion not to issue mandamus. You do not have any evidence of corruption in front of you. You don't even have a hint of
Where would that
take
take us?
If there were allegations of corruption, that would be an entirely different case. It's the
Exactly.
point you're making. And we don't need to decide how that would be dealt with.
I think that's right.
And indeed, wouldn't it be improper for us to decide how a hypothetical case such as that would be dealt with?
Your Honor, it seems to me that it's pretty fanciful to try to pull out that hypothetical and now to say that that should control in this instance, where you've got a clear constitutional provision that says the governor shall appoint, and the governor shall appoint within 60 days. And now to introduce some idea that there might be some future corruption.
Section 11, vacancies, judicial nominating commissions, one for each level of court, that is Supreme Court, appellate court, and trial courts. And so for each circuit, each of the 20 circuits, there's a nominating commission. For each of the 5 district courts of appeal, a nominating commission, and a nominating commission for the Florida Supreme Court. The Judicial Qualifications Commission. We were just talking about how judges are appointed, and most judicial positions are filled by appointment. Vacancies occur, and a judicial nominating process goes into play. Names go forward to the governor. The governor makes the appointments, and then someone's on the bench and is guilty of some kind of misconduct. What happens? Well, we know from our review back of Article 3, Section 17, that impeachment is a possibility. But now we see for the court system, we now see another way of having discipline for judges, and we see the Judicial Qualifications Commission, and the JQC process. The group of judges and lay people and lawyers who are on this commission now make important decisions. It has jurisdiction over all justices and judges, and can handle complaints. This can include complaints of incapacity if a judge is too ill or becomes too infirm to serve. Then the JQC has jurisdiction there too, not just in cases of misconduct. Note the membership of the JQC, and there'll be opportunities for you during your career to serve on judicial nominating commissions or the JQC, and if you have an opportunity to do that, do not pass it up. The commission now has rulemaking authority, those rules are subject to repeal by general law or by the Supreme Court. Where the JQC has a finding of probable cause, the judge shall then not be protected from public scrutiny. The proceedings now become public proceedings. Up until this point, we treat the JQ proceedings very much like a grand jury. We do not allow, they're not public proceedings, but after the charges are filed, there are public proceedings. The JQC can get information from other agencies. Florida Department of Law Enforcement, Sheriff's Departments, and others frequently have very important information. A provision in the Judicial Qualifications Commission section that I think is very important. This was adopted only after a number of lawyers, including me, made objections to the way that the JQC operated with the same people doing investigation of a complaint and hearing the evidence at the trial of the complaint. And what this provision does is set up these panels. So one is a hearing panel, which is established by the commission, and the other is an investigative panel. So it separates out, and that the same people are not doing the same work. Earlier, I thought there were very serious due process considerations, and made those arguments, which were rejected by the court. But shortly after those arguments were made, this change was made to the Constitution. By 2/3 vote of the panel, recommendations can be made to the Florida Supreme Court for removal of a justice or a judge. Our recommendations for their involuntary retirement. A simple majority vote of the hearing panel may recommend to the Supreme Court that the judge be subject to other appropriate discipline. So for removal, 2/3 of the panel. And it goes to the Supreme Court. No final authority to discipline or remove rests with the JQC. It rests with the Florida Supreme Court. Supreme Court receives these recommendations, and they may accept or reject them. And the Constitution makes it very clear that a judge may be removed for present unfitness to hold office, and may be involuntarily retired if they have any disability that seriously interferes with their performance of duties. A present unfitness is defined in the Constitution, and the JQC has authority to recommend to the Supreme Court what treatment the judge should get pending the final determination. A judge may be suspended from office with or without compensation, and Supreme Court may award cost, and the Constitution is quite clear that this power given to the JQC is cumulative to the power of impeachment. And indeed, we have a stunning example in the mid-1970s of an instance in which matters go before the JQC, from JQC to the Florida Supreme Court. The result is not satisfactory to the legislature, and the legislature then begins a impeachment process, which we have discussed quite extensively in our examination of the history of the Constitution. This section might seem quite hypothetical, but remember, we do have occasions in our history in which members of the Supreme Court themselves have been investigated and charged by the JQC. And so where we get into that circumstance, we can have substitute justices, and this tells us that they're the senior circuit judges throughout Florida. Prohibited activities. There was a time in which judges in Florida also practiced law. That is no longer permitted under the Constitution. The funding provision in Section 14 came into the Constitution with the Constitution Revision Commission action in 1998, providing that judges shall be paid state salaries, and this money be appropriated by general law. Section B makes it clear that that filing fees will be used to help cover the expenses of the court system. And subsection C says that that local government shall not have to pay for the court system. Again, remember back under the old Article 5, we had this large number of courts, and court functions were paid for out of local revenue. That's no longer permitted under this provision of the Florida Constitution. Subsection D, the judiciary shall have no power to fix appropriations. This came in with Constitution provision of 1972 and makes clear that on matters of appropriation, there's a separation between legislative power to appropriate and judicial power. We'll get into some really interesting cases and hypotheticals as we look at that further in other articles of the Constitution. State attorneys are provided in the Constitution, as are, attorneys' admission and discipline are provided for in the Constitution. And look at this. The Supreme Court shall have exclusive jurisdiction over the admission of lawyers and the discipline of lawyers. So now we have two bodies in Florida that have been organized pursuant to this Article 5, Section 15. One, we have the Florida Bar Board of Governors. Florida Bar Board of Governors deals with a variety of subjects, but include in those subjects are the discipline of lawyers. So the grievance procedures, once someone is admitted to the bar, grievance procedures are conducted under rules adopted by the Florida Bar, subject, of course, to the supervision of the Florida Supreme Court. Now, for admission of lawyers, a subject which might be of vague interest to you, the Supreme Court has organized the Florida Board of Bar Examiners, two separate institutions, different membership, different staffing. So when you deal with the Florida Board of Bar Examiners and have great dissatisfaction, as I expect you to have, don't think that that's the Florida Bar. It's not. It's a separate organization. And Supreme Court now controls both of these organizations, supervises both of these organizations, and we'll see some really interesting cases relating to that exclusive jurisdiction. Clerks of the court, provided for in the Constitution. Think about the possible conflict now between the clerks of the court, which have the duties given by special or general law, and note that clerks of the court serve as ex officio clerk to the Board of County Commissioners, auditor, recorder, and custodian of county funds. So there's a judicial side of a clerk of the circuit court, and there's a clerk of the circuit court in each county. Many circuits have more than one county, but in those circuits that have more than one county, there's more than one clerk of the circuit court. So we have a strange system here, and recognize the potential for conflict between the administrative authority, where the Chief Justice of Florida and the Florida Supreme Court get to control the administration of the courts, and yet one of the most important cogs in this machinery is the clerk of the court, and they are an independently elected constitutional officer. State attorneys, I stumbled a moment ago and said the state attorneys are in the Constitution. Well, they are. This is the least accountable office in the Florida governmental system. The requirements that state attorney be a lawyer for at least the 5 preceding years. Public defenders now are in the Constitution since the 1972 revision. Provision that all judicial officers shall be conservators of the peace. If you have friends who are judges, ask them what it means. And if you find out, please let me know. I've asked a number of judges what it means to be a conservator of the peace, and I've really never gotten a satisfactory answer. I've received some answers, but I hope that you can get better answers than I can, but I don't have any answer to pass on to you. Scheduled Article 5, this normally would not be very important, but it is important because, among other things, and I'm only giving you a portion of the schedule, it deals with the composition of the Judicial Nominating Commission. This was the original Judicial Nominating Commission, which had 3 members appointed by the Board of Governors of the Florida Bar, 3 electors who reside in the territory of the jurisdiction and are appointed by the governor, and then 3 who are not lawyers, who are selected by the first group. And this is the way the JNC was originally organized. But note that the Constitution, the schedule says for the judicial nominating commissions until changed by law. Well, law has made those changes, and now, sadly, we have, in 2014, we have a procedure which is dominated by the governor, returning us very close to the days when governors simply used the spoils system to select judges, and we don't have the same, in my judgment, do not have the same integrity for all the judicial nominating commissions that we once had. Well, that's a brief overview of our courts and how they operate. I look forward to our class discussions on this because there are a number of points that need to be filled out as we look at the case law. Thank you so much.